It's just, the pitch is to keep the system the way it is. But again, for the third time, by the time it all flushes out at the end of the day, we're not going to start over with a whole grievance procedure again. We're just going to go straight to arbitration. And so, in absence of that, we're right back to where we started, which means that the county has the last word. Because I understand that each of the commissioners appoints the personnel board members. I get that. But the thing is, the commissioners are effectively the employer. So they're appointing their arbitrators, so to speak. We don't have a right to appoint people to the personnel board. And I don't think you want us involved in that process. I mean, if you do, let's talk about that. But so ultimately, the county is the one determining the outcome.
Okay, I think we need to see what happens with...
I do have a question about your process. So when an employee comes to you and says, I've been disciplined, is there a committee that the Teamster puts together to evaluate whether or not it's for just cause or not just cause?
Is there, well, just on a daily, a disciplinary level, are you talking about cases going to arbitration?
Just initially, as it's pursued.
The business agent is responsible for making those decisions.
Okay.
And if there's a case where it is a 50-50 shot, I have the ability. First of all, I consult with my boss, Ken Wood, who's the principal officer and president of the local union. And if he decides, wow, this is really a 50-50 chance, what do you think, John? And I'll say, I don't know. That's the reason I'm here, because I don't know. I don't know which way to go with this. What do you suggest we do? It wouldn't be unheard of to put it before the executive board of the local union to make that decision. Generally, that doesn't happen, but it's there if it's needed. It doesn't really get past me. I've been around long enough to be pretty sure of what I'm doing. But on gray area cases, I do consult with my boss, and he usually, he's been in this a very long time. He's an international vice president. He's pretty high up the food chain, and he's pretty much seen everything that there is to be seen. And then we have a staff, Tom Polachek is our staff attorney. We run it by him. Tom, what do you think? Well, this case has been heard a million times, and there's about a 50-50 response. You're going to have to, let's just say that the discharge is based on a kind of a controversial thing, it's drug testing or something along those lines. He would give us advice what his experiences are. But ultimately, I'm charged with making the decision.
Okay.
Not the stewards. Because the stewards is going to be in there when the guy gets disciplined. He's going to do a background check on everything. He's going to talk to all the guys in the field, everything. And then they're going to, if it was me, then after I've done everything, I would say, hey, John, you guys wrong. John's right. Or I say, no,
the other way.
The other way around. Well, I'm not going to lie to him because I don't like having egg on my face.
So your experience when you tell the employee that you're not going to proceed further with it, you're not going to process it further, what's the employee's recourse at that point?
Well, the bottom of every grievance form has a clause that says, I understand, I don't have one in front of me, but I understand and agree, something along the lines that the union has complete discretion.
Yeah, I was curious about that.
And it's happened, it's only happened to me once. I've had an attorney call me up over my unwillingness to pursue a grievance matter, and it was over layoff language, and I told the attorney, I said, have you seen the grievance form? Yeah, I said, do me a favor, while we're on the phone, look at that last paragraph and tell me what it is that you have to talk to me about, because it's pretty clear. Unless there's just a gross miscarriage of justice with me not representing a member fairly, that's a DFR issue. But this not pursuing the grievance, it's pretty clear in the grievance form, that we have control over that, and so, and otherwise, if we didn't, it would just be a free for all. And then we'd end up like some of these local unions that are bankrupt because they spent all their money on stupid arbitrations that should have never been heard. But when we lock into a case, we lock into a case, and that's one thing that we have a reputation for, is that when we're right, and we're going to prove that we're right. So,
All right, I mean, I don't want to give you a sense of false hope by all the questions we've asked about it, but it is, your point of view on it and understanding how your process works does help us to anticipate what we might have to deal with if we change our position on it. I'll say candidly, we're not at this particular point that big a fan of the combination of just cause and arbitration, because I think we're in a time period right now, there's a very anti-government sentiment throughout the country that is filtered into the arbitration process. So we go into that process believing that the deck is stacked against us, just so you know. And I think statistically over the last, let's say 3 or 4 or 5 years, the stats support us on that.
Well,
just
yeah, I mean,
because of the fact that people don't have a good feeling about government at an upper level or a local level.
are you saying that those feelings are conveyed into an arbitrator's mindset or something? Or
Oh yeah, definitely.
do you think arbitrators have a problem with?
I think we've seen more bias on the part of arbitrators in the last couple of years than ever before.
leaning more pro-labor.
Oh yes.
Oh.
I don't want to say that's not really true. That's not my opinion. It's not that it's pro-labor. It's pro-employee.
Well, and on the subject of just cause decisions, I mean, that road's been traveled a million times. I mean, I don't think an arbitrator has a whole lot of leeway to dispute facts that are put in front of them.
I think they have a ton of
I
flexibility in
disagree.
interpreting, because when you look at the ability to challenge the outcome of an arbitrator's ruling under Florida law, it's extremely limited. So, and the
challenging
arbitrators know
arbitrator's decision
that.
is a whole different thing. When we have a contract provision that says an arbitrator's decision is final and binding, and then the next thing you know, well, we're going to district court. Well, why is that? Because we disagree with the arbitrator. Well, don't we have a clause that says that it's final? Yeah, but he was outside of the scope of his authority, and he ruled on something he shouldn't have been. Come on, man. We have an arbitration process to keep us out of court. If every single time we get a decision we don't like, we end up in court, the whole thing's a waste of time. We might as well just go to court for everything. And I, for one, as much as I just got to swallow a whole lot of pride, will accept an arbitrator's decision that I thought was slanted 110% against the union, and I've had those cases before. But you know what? You live by it. The arbitrator was mutually selected out of a panel. We both struck a bunch of names that end up with the final guy or gal, and what they come up with is what they come up with, and that's like I said, I've had Thompson, Sizemore, and Gonzalez. I don't know if you know that law firm. They're
Very well,
pretty,
sure.
I've had Tom Gonzalez challenge a decision of an arbitrator, and I've had that same discussion with him.